And the record shall now show that the jury is in the courtroom. And Mr. Allen, I believe you are the jury foreperson.
Yes, sir.
And we have received a message on behalf of the jury that the jury has reached a verdict in this case. Is that so, sir?
Yes, sir.
Is this verdict a unanimous one? That is one that is agreed upon by all members of the jury.
Yes, sir.
And do any of the jurors disagree with the foreman's representations? No disagreement is evident. I'm going to ask you, please pass the documents to the bailiff. You may be seated. I am going to review for proper form and publish the verdict. And the defendant shall rise. In cause number 23, CR 2122, the state of Texas versus Terrell.
All right, lock in. This is the moment every trial builds toward. The jury is back. The courtroom is silent. And within seconds, someone's entire future is about to change. Watch closely how formal and precise this process is. Every word here matters.
Zebediah Thomas, we, the jury, find the defendant guilty of the offense of aggravated kidnapping as charged in this indictment signed by the jurors foreperson. The verdict is received. It is made a part of the record for this case for all purposes. You may be seated. Thank you. Ladies and gentlemen of the jury, at this time the court has received your verdict, finding the defendant guilty of this offense as alleged the first-degree felony of aggravated kidnapping. We will now proceed to the punishment phase of this trial. Since this is a bifurcated trial system, we work one stage at a time. This is guilt or innocence. You've resolved that, finding the defendant guilty. I'm going to repeat that you are still under all the instructions that the court has given to you in this case. Now, we're going to break for the lunch hour here in just a few minutes. There are certain legal matters that we must take up before we break for lunch. Are the parties ready to proceed? As the court has accepted this verdict, now we proceed to the punishment phase. There are 4 additional paragraphs to this indictment. Is the state ready to proceed?
Yes, Your Honor.
And the defense?
Yes, Your Honor.
I'm going to ask the state to, the defendant shall rise, please. I'm going to ask the state to begin with paragraph 2 of the indictment and its allegation, and then I will ask at the end of that presentation how the defendant pleads true or untrue to the allegation. Then we will go to paragraph 3, 4, and 5 in that order of this indictment. Beginning with paragraph 2, now the state may proceed.
And the grand jurors aforesaid upon their oaths aforesaid be further present in and to said court at said term that before the commission of the primary offense, the defendant was finally convicted of the felony assault on a public servant, 3rd degree, on July 24th, 2000, in cause number 099-2349 in the 299th Judicial District Court of Travis County, Texas.
Terrell Zebediah Thomas, you've just heard a reading of paragraph 2 of the indictment, alleging that you have a final conviction of assault on a public servant on July 24th, 2000, out of the 299th Judicial District Court of Travis County, Texas. How do you plead to that allegation? Is that true or untrue, sir?
True.
Untrue? Untrue will be entered into the record on your behalf. Next, paragraph 3.
And the grand jurors aforesaid upon their oaths aforesaid be further presented in and to said court at said term that before the commission of the primary offense, the defendant was finally convicted of the felony of robbery, 2nd degree, on July 18th, 2000, in cause number 001614 in the 299th Judicial District Court of Travis County, Texas.
Terrell Zebediah Thomas, as defendant in this case, you've heard a reading of paragraph 3 of this indictment, alleging that you have...
That's it. Guilty. No hesitation. No split jury. This was unanimous. In Texas, aggravated kidnapping is a 1st-degree felony, meaning the stakes are already sky high. But here's the thing. This verdict isn't the end. It's just the beginning of the punishment phase, where things can get even darker.
A felony conviction previous to this case of robbery, a second-degree felony, on July 18th, 2000, out of the 299th Judicial District Court of Travis County, Texas. How do you plead to that allegation? Is that true or untrue? Untrue. Untrue will be placed into the record on your behalf. Next is paragraph 4.
And the grand juries aforesaid, upon their oaths aforesaid, do further present in and to said court at said term, that before the commission of the primary offense, the defendant was finally convicted for the felony of assault on a public servant, third degree, on March 26, 2002, in cause number 14-705 in the 35th Judicial District Court of Brown County, Texas.
Terrell Zebediah Thomas, as defendant in this case, you've heard a reading by the state of Texas of paragraph 4 on this indictment, which alleges that you have been finally convicted of the felony of assault on a public servant, a third-degree felony, on March 26, 2002, in the 35th Judicial District Court of Brown County, Texas. How do you plead to that allegation, true or untrue? Untrue is entered into the record on your behalf, and the state may read the allegation contained in paragraph 5.
And the grand jurors aforesaid, upon their oaths aforesaid, do further present in and to said court at said term, that before the commission of the primary offense, and after the conviction in clause number 0992349 became final, and after the conviction in clause number 001614 became final, and after the conviction in clause number 14-705 became final, the defendant committed the felony of felon in possession of a firearm, second degree, and was finally convicted of such felony on December 6, 2006, in clause number D-1-DC-06-200790 in the 390th District Court of Travis County, Texas.
Terrell Zebediah Thomas, as defendant in this case, you have just heard a pronouncement and reading of paragraph 5 of this indictment, which alleges that after the convictions in paragraphs 2, 3, and 4 were final, that it is alleged that you committed an additional offense, a felon in possession of a firearm, a second-degree felony, and were convicted of that offense on December 6, 2006, in the 390th District Court of Travis County. How do you plead to that allegation from paragraph 5 of this indictment, true or untrue? Untrue. Untrue is placed into the record on your behalf. Everyone may be seated. Ladies and gentlemen, we're going to break, and can all of you return back at 1:15? Please remember the instructions the court has given to you, and we'll see you all in about an hour and 15 minutes. Everyone else remains seated while the jury exits first. Thank you. Record shall show that the jury is seated in the courtroom, and Mr. Allen, as foreman of the jury, the court has received a message on your behalf that the jury has reached the verdict in this punishment phase of the trial. Is all of that true? Yes. Is this verdict a unanimous one? That is one that is agreed upon by all members of the jury? Yes. And do any of the jurors disagree with your foreman's representations? No disagreement. It does indeed appear to be unanimous. If you would be so kind, please pass the documents to the bailiff. You may be seated. The court will review for proper form and publish the verdict.
Quick legal breakdown. Texas uses a bifurcated trial system, which means guilt and punishment are decided separately. The jury just answered, did he do it? Now they'll decide how long should he pay for it. And that distinction matters more than most people realize.
And the defendant shall rise. In this cause number 23 CR 2122, the state of Texas versus Terrell Zebediah Thomas, we, the jury, find that the additional allegations in the indictment are true, and that prior to the commission of the offense, this offense being aggravated kidnapping, for which the defendant has been found guilty, The defendant was convicted of 2 or more previous non-state jail felony offenses, and that a subsequent previous conviction was for an offense which occurred after the first previous conviction had become final. We assess punishment at confinement in prison for a term of 55 years. Signed by the jury foreperson. It is received, made a part of the record for all purposes. You may be seated. Ladies and gentlemen of the jury, at this time, your duty as jurors is completed. I have received your verdicts in the guilt or innocence phase of this trial, finding the defendant guilty of the first-degree felony of aggravated kidnapping, and thereafter assessing his punishment at confinement in prison for 55 years. At the beginning of the trial, I placed you under a number of instructions. At this time, I am releasing you from all those instructions previously given to you. However, one additional note, once you are discharged, you are released from your oath of secrecy. You are free to discuss the deliberations and your experience as jurors. And you are also free to refuse to discuss the case, and you have every right to maintain your silence unless otherwise ordered to do so by the court. Now, once you are discharged, I've got to speak to the attorneys for a few minutes, then they will be released, and they always like to get feedback or input from the jurors. If you're willing to stay behind, they will be here, outside in a few minutes. And it always helps them to do their job better when they get input from jurors. You are free to discuss or not discuss these matters as you choose. I want to thank you for being part of We the People. And sometimes we are called upon to make very important decisions that are the essence of the Constitution of the United States. The right to a trial by jury needs jurors, good people to come forward and make good decisions. I hope to have the honor to work with you in the future. Until then, may God continue to bless Jefferson County and her citizens, and you are excused. Thank you very much for your time and your service. Also, Ellie has documents if you need it for work or school or other purposes. All right, is there any legal reason why formal assessment of judgment in this case should not be made at this time?
No, Your Honor.
Terrell Zebediah Thomas, you came before this court and a jury, entered a plea of not guilty to the offense as set forth in the indictment, aggravated kidnapping, a first-degree felony. The evidence was submitted. The jury was charged by the court. After deliberating, the jury returned a verdict finding you guilty of this offense, the first-degree felony of aggravated kidnapping. Thereafter, evidence was presented on the punishment phase of the trial. The court provided jury instructions. Arguments were made. Presentment of evidence was made. The jury went and deliberated and assessed your punishment at 55 years confinement in prison. It is therefore the judgment of this court that you are guilty in this cause number 23 CR 2122, and that you shall be punished in accordance with the jury's verdict. The court does not see or hear any legal reason why sentence should not be pronounced at this time. If nothing by the parties, it is therefore the order of the court that you, Terrell Zebediah Thomas, being judged guilty of the first-degree felony of aggravated kidnapping in this case, shall be imprisoned in the Texas Department of Criminal Justice for a term of 55 years. You shall be delivered by the sheriff of Jefferson County, Texas, to the director of the Texas Department of Criminal Justice's Institutional Division, or any other person legally authorized to receive such convicts, where you shall be confined for 55 years in accordance with the laws governing the Texas Department of Criminal Justice's Institutional Division. You are here now remanded to the custody of the sheriff of Jefferson County, Texas, until she can obey and carry out the directions and instructions of this sentence. Your sentence shall commence this day. You will receive credit for all time you have served or periods of detention as provided by law in conjunction with this case. Anything to bring up by the state?
Judge, if you stated, do you want to state on the record that this carries affirmative finding. I didn't hear it, but you did.
What does the defense say on it?
With regard to deadly weapon finding, Your Honor, it's alleged in the indictment, and I believe found as an element. I don't have a legal objection.
Right. Actually, I don't believe it's going to make a practical difference because he's been convicted of an aggravated offense, which carries with it a parole of 50% less good time. But the judgment shall, in completing what information needs to be assessed and determined, completing the finding by the jury's finding of guilt beyond a reasonable doubt based upon the four corners of this indictment, the defendant, it is going to be affirmatively shown on the judgment that the defendant used a deadly weapon, namely an accelerant, which the indictment alleges, and dousing the apartment with an accelerant, and that the victims were, the complainant and victims that were involved in the kidnapping were held against their will in the apartment, within the apartment, as and while flammable liquids were doused about the apartment, and the evidence shows that the defendant threatened to ignite the accelerants. The court finds that those findings are sufficient to show that a deadly weapon, namely a flammable accelerant, and in this case, it was the item exactly was from the state, flammable liquid, which was
The accelerant, Judge.
which was
It was lighter fluid. That in combination with the Clorox.
okay, lighter fluid and Clorox were was the information and evidence presented in this case, and the court finds that it was deemed by its admission and determination by the court, the jury verdict, that it should be placed in the record and in the judgment that that item was used, those items were used as deadly weapons because they are capable of causing death or serious bodily injury. And it was used affirmatively in a threatening manner by the defendant. Anything else to add from the state or the defense?
No, Your Honor.